Well, hello everyone, and welcome to this employment law session. I'm Lior Samfiru, the employment lawyer. That's what they call me. I am, of course, one of the founding partners of Samfiru to Markin LLP, and I'm here every week on this day at this time to talk to you about employment law, more specifically to answer your questions. This is a live session designed with you and for you to get you answers to your employment law questions, your workplace issues, and to make sure that you have the knowledge that you need to have. I'm again Lior Samfiru with Samfiru to Markin LLP. We are the largest employee law firm in the country. You can find us in Ontario, in BC, and in Alberta. And if you have a question you wanted to ask, if you were something that you've always wondered, now is the time to ask that. Maybe you're mistreated by your boss or your coworker and you want to know what to do, what your rights are. Ask the question. Maybe it's a situation where your job is being changed. You're being given different responsibilities or different hours, different shifts. What to do? What can the law do to help you? Ask the question. Maybe like so many people, you've lost your job recently. You want to understand, what does that mean? Can they even let you go? What are you owed? What should you do with that severance offer? I can tell you, I can give you the information. You can ask the question right here of me live. You type it in, I'll read it, I'll answer it, and you can walk away with that knowledge. So please make sure that you ask those questions. Now, before I start answering, I'm going to give you some more contact information. If you want to connect with me and my team off social media, so easy to do. You just go to employmentlawyer.ca. Look at that. The address is on the screen right now. Employmentlawyer.ca. And you can get my phone number, my email address, the contact information for my entire team. If you prefer, you can fill out a form and my team will call you. Easy to do. It's all there, employmentlawyer.ca. But right now, you got me for the next 30 minutes right here, right now, live answering questions. This is a live session with me, Lior Samfiru, the employment lawyer. Questions have started coming in, so I think I'm going to just start answering. But you got time, right? So I'll answer. Ask your question, okay? Ask it right now. All right, let's start in order. First question on YouTube from Silver Star. Love the name. Anything to take into consideration when applying for a job that requires travel between the US and Canada? It's a Canadian company. Travel and accommodation is part of the package. So certainly you want to make sure that your employer deals with any travel visas or any visas that may be required. Usually you won't need a visa to the US depending on how long you stay. So you want to confirm that. Obviously, you want to make sure that there is insurance, that you're insured if something happens medically while you're there, so that the employer actually has insurance that applies to you. Right here at home, if you're insured, we have coverage, of course. We have healthcare. In the US, it's different. You want to make sure you have that insurance. So of course, you also want to ensure that the timing of that. So how long are you going to be required to travel? Is it open-ended? Can they make you travel every day, every week? You want to agree to terms on that so you're not surprised later. You don't want to find out that you thought travel was going to be once a month and it becomes once a week. So you want to agree to that and agree to it in writing. So those are a few things, of course. If your employer asks you to sign anything to make this happen, I want you to call me. Do not sign anything without calling me. It could be an opportunity for your employer to sneak in terms that you won't want, such as a termination clause. In essence, something that would allow the company to let you go by not paying you your full severance. So obviously, if you're required to sign anything, you don't do that until I see it. All right, Silver Star, hopefully that makes sense. Great question. See how easy it is, everyone. Silver Star had a question, asked it, I answered it. You got time to do that as well. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru to Markin LLP. And I have more questions here to answer. I'm going to do that. You got all the time in the world. I want you to be that second voice on this live stream, and you can do that by asking your question. All right. A. Brown has a question. Can a U.S.-based employer enforce an at-will employment contract on Canadian employees? Absolutely not. That at-will employment agreement is not worth the paper it's written on in Canada. I see this all the time. companies that are based in the US have a certain employment agreement, a certain contract that they use in the US, and they think they can use the same thing in Canada. Not even close. There's no such thing as at-will employment in Canada. Really, at-will employment in the US, it means that they can do whatever they want, let you go whenever they want, pay you nothing. Does not exist in Canada. Not worth the paper it's written on. So you have the protection and the rights that are available under Canadian law. It doesn't matter what province you're in. We have pretty darn good employment laws at any province here in Canada. So no, don't worry about that. That said, it's certainly always going to be a good idea not to sign something without me seeing it first, okay? Always a good idea. It doesn't matter where the company is from, what they're asking you to sign, I should see it first. But at-will employment, waste of time, waste of effort for the company to even bother with it. Hopefully that makes sense. Abraham, any follow-up questions? Hey, guess what? I am right here. Great stuff, guys. I want lots and lots of questions today. I want to be busy for the 30 minutes, just answering your questions. Again, I'm Lior Samfiru, the employment lawyer. I have more questions to answer, and I want yours as well. Wrongful dismissal, constructive dismissal, discrimination, human rights violation, mistreatment. You get it. I can answer it. I can tell you what you need to know. Ask your question. All right. Let's see. Paul, I'm not sure. I think it may be Paul. The font is a bit off here. Paul has a question. He says that he usually listens, but today has a question. Paul's asking, can my employer force me to use my personal cell phone as a tracking app for timing records? No. The short answer is no. What I mean by that is that if you refuse, they can't fire you for cause. What they can do, hypothetically, is they can let you go with severance. And the reason is that an employer can let you go for any reason, really, as long as they pay severance. So hypothetically speaking, can they say to you, if you refuse to do this, we will let you go and pay you your full severance? They can. I think that would be silly for them to do, but they absolutely could. So it's not, if you refuse to do that, it's not a form of misconduct, which means they can't discipline you. They can't fire you for cause and avoid paying you severance. So if they're going to draw a line in the sand, you may have to decide then what is better for you. Is it better to do what they're asking and use your phone? Or is it better to leave with severance? That's obviously a personal decision. So can they force you? No. Can they let you go with severance? Yes. Hopefully that makes sense. But hey, I'm not gone anywhere. Still here. Plenty of time. So if you have other questions for me, no problem. Just ask them. All right. Guys, it's going to be another one of those great days. Lots of questions coming in. You see the smile on my face. I'm very happy about that. I want those questions. All right. Let's continue answering them. If you've just joined us, first of all, welcome. I'm Lior Samfiru, the employment lawyer, here live answering your questions about employment law, about workplace rights, trying to help you solve your workplace situation. All right, let's see. Facebook, our next question comes from Lauren. My employer hosts a company-wide off-site conference, which takes place over 3 days. Yesterday, I traveled in, worked from 7 a.m. to 8 p.m., and then again from 9:30 to 11:30. Had to be back again this morning at 8 a.m. and will likely be here until evening again. What are the employer's obligations for cases like this? So if you have to be at that conference, so it's not that hey, we're doing this, it could be beneficial, you should come. That's one thing. If they say this is mandatory, you need to be here, well, that's work time. So you have to get paid for that time, and certainly if you're an hourly employee, and those hours would count towards your overtime. So depending on your province, the overtime rate could be 40 hours a week or 44 hours a week. For example, in BC, it could also be 8 hours a day. Anything more is overtime. So that time in that conference counts towards those hours. So it's essentially you are working. Even though you may be sitting on a chair listening to your employer talk, if you're required to be there, it's work time. So you look at it as work time. So the same rights that would apply if you were working apply in that situation. It's a simple way to put that. Hopefully that makes sense. Questions, follow up, other issues, reach me, easy. By the way, all of you, to connect with me off air, to get my help, my attention off social media, off live stream, myself and my team, so easy to do. You just go to employmentlawyer.ca. Hey, look at that right there on the screen, employmentlawyer.ca, and you can connect with me. All the contact information you can ever need is right there. But right now, you don't even have to worry about that. Right now, I'm live, you're watching me. You can ask a question as well. I want those questions, and they're coming in, so let's continue. Yusuf has our next question. Yusuf says, if the insurance company provided incorrect medical information to your employer, which was then used in a WCB claim, and later they acknowledged the mistake and apologized, can I sue them? Potentially. I mean, if they were negligent, again, I would have to understand much more. But if your insurance company was negligent somehow, and they were supposed to do something and they didn't do it properly, and this cost you something, potentially you could go after them. Absolutely. But you'd have to show that they were negligent. And I'm not sure exactly what you mean, because there's a difference between an insurance claim and a WCB claim. So obviously I would want to understand much more. But yeah, potentially you could take legal action. For that, let's have a proper consultation. I want to understand what happened, what was said, who said it to who, etc. To connect with me and my team to do a proper consultation. I gave you that information. I'm going to give it to you again. Employmentlawyer.ca. Again, employmentlawyer.ca. That simple, that easy to do. Connect with me and we'll have that chat. All right, let's see. Let's see. Next question comes from Joey Break. Joey Break on YouTube asks, I've been with my company for 13 years. The employer is now saying that they're changing things up and staff are being moved to new shifts and duties. Can they let me go if I refuse this change? Fantastic question. So the devil's in the details. So we need to know what kind of a change. I'll give you an example. If they were to say, hey, instead of working 9 to 5, you're going to work 8:30 to 4:30, that's a small change, so they can do that. And if you refuse, potentially that could be considered a resignation, actually. On the other hand, if they were to say, instead of 9 to 5, you're going to work 12 to 8. Wait a second. Absolutely not. That's a huge change. So if you refuse, and as a result, they let you go, they have to pay you your full severance. So the question always is it a significant change, or is it a minor change? A minor change they can get away with. A significant change, no. That said, even if they're trying to implement a significant change and you refuse, they can let you go, right? Because as I said before, an employer can let you go pretty much for any reason, but they would have to pay you your full severance. You said you've been there for 13 years. You could be owed a year's pay or more than a year's pay. That could be your severance. So that's really the answer. But if they make a minor change and you refuse it, that could be a problem. So Joey, the best thing I can tell you is we need to deal with your actual situation. So what I want you to do is I want you to connect with me and my team off air, and I want to understand exactly what they're doing, when they're going to do it. And on that basis, we can say exactly, here are your rights and here are your options. So Joey, to connect with me, to do that, right now you can do that. Anytime you can do that. Just go to employmentlawyer.ca. You see that address right there. Employmentlawyer.ca. Phone number, you'll find it there. Email address, you'll find it there. Every contact information you can ever think of is right there. Thank you for that, Joey, and look forward to connecting. All right, more questions. With me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Latayan, sorry if I mispronounce, I apologize. I'm doing my best. Latayan says, if you were wrongfully terminated, you did not get all the severance pay. Does it mean you have to go to court, or does that usually end at negotiation? It is extremely unlikely that you will ever have to go to court over the severance issue. 99% of matters resolve way before going to court. In fact, they resolve within a few weeks. So no, it's not complicated in 99% of cases to get you the severance that you need. It simply starts with giving us a call, having us assess what you're owed, and then we can deal with your employer to get you that severance. No, the chances of you going to court are the same really as you getting hit by lightning. It's just not going to happen for the vast majority of cases. So don't worry about the process. Don't be concerned or scared or worried about that legal process. When it comes to severance, it's not complicated. There's other things that could be complicated. When it comes to severance, it's usually straightforward. And usually once the company hears from us, they kind of put their heads down. They say, crap, they called us on it, and we negotiate proper compensation. Okay, so Latayan, you know what to do. If you were let go, someone you was let go, so easy to do. Just connect with us through employmentlawyer.ca. Again, employmentlawyer.ca. But this is a good opportunity in answering Latayan's question to tell you more about how to find out about the severance that you are owed. How do you know if you're owed 6 months severance or 18 months severance, 24 months severance? How do you find out? Hopefully, this is not going to come as a surprise. We have a tool for that. Grab your phone, your desktop, whatever you want, and go to pocketemploymentlawyer.ca. That address is on the screen right here, pocketemploymentlawyer.ca. When you go there, you simply click on the severance calculator. Ta-da! There it is, right there. The tool that you can use to find out in seconds how much severance you're owed. Completely free, completely anonymous. You couldn't pay for it if you tried. All right. So again, pocketemploymentlawyer.ca. Use the severance calculator. Over 2.5 million people across Canada have used it to date. And it's the very first place you should go to if you want to get a sense, an understanding, an assessment of what is the law when it comes to your severance, how much severance you should get. Pocketemploymentlawyer.ca. Check out the severance calculator. And if you want to, only if you want to, you can contact me directly from that severance calculator. All right, let's see. Continuing to answer questions. I love it when questions are coming in. Oh my God, I'm happy. Let's see. Next question from Della. Della asks, what happens if you send an initial demand letter to negotiate severance and the employer still has not responded 2 weeks after the due date? Does litigation commence? What are the next steps? Well, if you're owed more and the employer has not responded, then yeah, we'll start a claim and we'll force them to respond. Once you commence a claim, commence legal action, they have to respond. So it's not a problem. It happens rarely. Generally speaking, we would follow up and I can count on one hand the times that the company has not responded to us. So usually doesn't happen, but even if it does, there's ways to force them. So it's not a problem. That's why you need to deal with a legal professional, someone that does this for a living, someone that's seen everything, that's done this 1,000 times last month. So that's why you need to speak with the professionals. Call us, again, employmentlawyer.ca to get that information. And very important, I said this earlier, and I'll say this to you, Della, don't be concerned about the legal process. If you're working with someone that knows what he or she is doing, we're going to get this resolved. We're going to get it resolved quickly, and we're going to get it resolved on good terms. Okay, don't be afraid of the process. We're right here for you, employmentlawyer.ca. All right. Silver Star, I think, has another question. Let's go ahead and answer it. Can your employer slowly remove you because of several employees that don't like you? Does it matter if your employer is happy with you despite the other employees? Remember what I said earlier. Your employer can let you go pretty much for any reason as long as they pay you severance. So can they let you go even though there's really not a good reason? Yeah, actually they can, but they have to pay you severance. If you're asking me, can they use that to fire me without severance? No, absolutely not. They can't. But if your employer wants you gone despite the fact that there's really nothing that you did wrong, yeah, it may be unfair. It may even be unethical. But from a legal standpoint, really it comes down to severance. And the reason why you hear me often talk about severance, use that word severance so often, it's because from a legal standpoint, it comes down to that. If you're mistreated, you can force the company to pay you severance. If you're let go, you get severance. That's how the law deals in compensation. So Silver Star, can they do this? Yes, but they have to pay severance. And of course, that severance can be as much as 24 months pay. As I said earlier, if you want to know how much you're owed or get an assessment of that, use our severance calculator at pocketemploymentlawyer.ca. Okay. Let's see. What red flags, this is from Jordan, sorry, and Jordan has our next question. What red flags should you look for in contracts when seeking disability or life insurance? So generally speaking, those contracts are standard. Okay, you can't really negotiate those contracts for the most part. Okay, they're pro forma contracts, so there's not going to be a heck of a lot there. Of course, you have to make sure that you answer the questions truthfully, because the problem is you may you may answer a question and they ask you about your hobbies as an example for your life insurance, and you like mountain climbing, and you don't say that. You just say that you like to play the piano and to play video games. Later on, if they find out when something happens that you had a mountain climbing hobby and you didn't tell them, they can cancel the insurance, because they say, well, we didn't know that we were taking the risk of someone that climbs mountains. If we did, we wouldn't have given you the insurance. So they can cancel it. So the key is to answer all the questions fully and truthfully, not to give the insurance company an excuse later on to void the insurance. Okay, so hopefully that makes sense. But otherwise, the contracts generally are pretty standard. All right, more questions. Fantastic. I'm going to continue answering. I'm Lior Samfiru, the employment lawyer. Let's get questions answered. Sherry has our next question. Sherry is joining us on Facebook. Our company may be sold. If they get rid of my job, do I still qualify for severance? So yes, if you lose your job as a result of the sale, you are owed severance. The seller, the company that's selling the company, would be liable to you to pay you your severance, and that could be as much as 24 months pay. That's if you end up losing your job as a result of the transaction. Now, if you continue working with the buyer, so the buyer hires you on to do the same job, then you don't get severance, but they generally inherit your service unless you sign something that says otherwise. All right, so you want to be careful. Don't sign something with the buyer, if you're going to work there, that potentially says that you don't get any credit for past service. Of course, if you're offered something to sign, you're offered a job, let me know. Okay, I want you to connect with me through employmentlawyer.ca. Let me see that. But if you lose your job, also, you must connect with me. We need to make sure you get the full severance, not what the company is offering. There's a 90% chance that what the company is offering you is not even going to be close to adequate. So that's why you connect with us, connect with me, my team, employmentlawyer.ca. All right, so that's from Sherry. Thank you for that question, Sherry. Man, more questions. Oh my God, what a great day. I love it. Kevin, how you doing, Kevin? Kevin has our next question from Facebook. Is there anything one can do when a company and union forces a worker out after 26 years of service? This happened in 2020, and the union refused to let me take the paperwork to a lawyer. Unfortunately, it's not that they refuse to let you take the paperwork, it's that the lawyer can't do anything for you. If you are let go, if anything happens with your employer and you're unionized, the only one that's allowed to help you is your union. You cannot hire a lawyer. The lawyer can't do anything for you. By law, it has to be the union. And of course, the problem is if the union doesn't want to help you, or is not doing a good job, or just doesn't get it, you don't really have many options. You can file a complaint against the union with the labor board, but in most cases, that's not even going to be successful. So that's the problem. By the way, everything you hear me say on these sessions right here on these live stream only applies to non-union employees. None of what I say applies to unionized employees. All right, more questions. Let's get them answered. Kim on Facebook has a question. My company bought another company. New contracts are being issued. My old contract stated I was entitled to common law severance and ESA entitlements. New contract states literally no common law severance. New contract states, however, my time served under my old company is applied to this contract. So what they're trying to do here, of course, is eliminate your future severance entitlements. Let me just see. So the effect of that could be huge. It could be the difference between getting 2 months severance and getting 2 years severance. Huge. So best advice is don't sign it. Okay. If they let you go because of this, at least you could get your full severance. So I wouldn't sign it, but not without me seeing it first. This you could literally be. It could literally cost you tens of thousands of dollars, maybe even hundreds of thousands of dollars. So very, very, very problematic, and a kind of a sneaky thing, an unfair thing to do to an employee that's been there for that many years to try to have them sign something that's almost guaranteed to cost them a lot of money. Don't sign it without me seeing it first, Kim. You may absolutely be able to say, not signing it, happy to continue on the same basis, but I'm not signing this. They can't punish you for that, okay? So, but before you make any decision, I want to see the contract. You want to connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Thanks for that, Kim. All right, let's get some more questions in. Samuel, I've been working on contract for 7 years now. The factory I work at has hit a bit of a slowdown, and they are saying some people may not be up for renewal. Would I be owed severance? You better believe it, yes. After 7 years, the law is likely going to be considering you a regular employee. Doesn't matter what you sign, what they say, meaning you're going to be owed severance. So the fact that they say contract doesn't change that. So yes, you're going to be owed severance. And again, 7 years, I don't know exactly the job you're doing or your age, but it could be anywhere from 6 to 12 months, frankly, of severance, depending on those factors. So if you lose your job, okay, if you lose your job, Samuel, you call me. You connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right. Thank you for that, Samuel. Fantastic question. I get that question often. Don't worry about the whole contract thing. Yes, you get severance. Connect with me, employmentlawyer.ca. All right. I'll take one more question here. If an employer is claiming, this is from Beguiling. If an employer is claiming that a workplace accommodation is too much, what is the threshold for that to be the case? Can they let me go because of an accommodation request? So first of all, let's start with the second part. Can they let you go because of an accommodation request? Absolutely not. Illegal. Human rights violation. Whether they can or cannot accommodate, what they're not allowed to do is to let you go because you need accommodation. But the main question is, what is the threshold, the standard for accommodation? It's a very high standard, a very high bar. It's only in situations where it's going to be so costly, so complicated that it's going to create massive problems. It's only then that the company can say, wait, that's just too much. We don't have to go that far. We call this accommodation to the point of undue hardship. In other words, even if it's hard, the company still has to accommodate. And in my experience, too many times the company says, no, we can't, when they in fact could. They're choosing not to. And that would be a human rights violation. So depending on your accommodation, it's very likely that they have to accommodate, but perhaps they're just not trying hard enough. Give me a call, okay? Let's connect with it. Oftentimes they may say no to you. No, we can't accommodate. As soon as they hear from me, oh yeah, of course we can accommodate. No problem. We'll take care of that right away. So let me take a shot at it. Let me deal with that for you. Again, employmentlawyer.ca, very high standard for the duty to accommodate. Guys, by the way, next session that you'll have here is tomorrow, the 12th of September at 12:30 p.m. Eastern with my colleague Alex Lucifero, who will talk about employment law and disability law. Guys, for today, this is the time that we've had for our session. Lots of questions from beginning to end. I love it. If you didn't get your question answered, I'm not going anywhere still. You can still connect with me and my team anytime through employmentlawyer.ca. Today, tomorrow, weekend, whenever you want. So again, employmentlawyer.ca. You can send an email. You can make a phone call, fill out a form. It's all there. I'm the employment lawyer, Lior Samfiru, with Samfiru to Markin LLP. I was here live with you answering questions. I'll be back next week to do the same thing, but don't wait until then. Just go to employmentlawyer.ca. Guys, thank you so much for joining me today. Always a pleasure. We'll talk to you again all soon. Take care.